Good afternoon. Thank you all so much for joining us again. We're on episode 17 of Stewarts Soundbites, but we are on actually episode 2 of this mini series, which is a guide to the litigation process. I'm going to try really hard not to ramble in this first section because we're under time pressure. But this week we've got Ben Townsend, who's a partner in the PI team in Leeds. Last week we had Dan Herman, who talked about the initial stages of cases, so meeting the client, setting up case management and therapies, interim payments and all that good stuff. And this week we're moving on to look a bit more at the evidence prepared in these sorts of cases. So we're going to talk about how we build and present case evidence in these cases and how crucial that is in terms of achieving the best results for our clients and obtaining the sums of compensation that they deserve and they need. So I'm going to jump in. Ben, thank you so much for agreeing to come on today and talk to us a little bit about this. So the first section we're going to talk about is documents and disclosure and a bit about document preparation, and then we're going to talk a little bit about expert evidence. But to start with the former then, in terms of documents, can you explain, for the benefit of everyone who's tuned in, that what we as solicitors are obliged to obtain and to disclose in these types of proceedings, and whether there's a difference in terms of documents pre-court proceedings and after court proceedings have been commenced?
Yeah, sure. Yeah, documents are really key to these cases. Documents will set out for us in relation to the client, the rehabilitation that a person has been receiving, the interventions that they've had, the support that they've had from any care staff that they have. It's going to be really important to show that to the court and to show the difference that the interventions have had with the injured person. It's not enough to just say they need to have a particular intervention. They need to be able to show that it makes a difference to their lives, and the documents are key to that. Now, generally speaking, there's not going to be an automatic obligation to disclose documentation before the formal commencement of court proceedings, as far as what we call the quantum documents are concerned on the claimant's side. That is, the documents like medical records, like the case management records, the rehabilitation records. But nowadays we do try and reach agreement where we can between the sides. It's not as adversarial a process as it used to be. So agreements between the parties to, say, provide ongoing rolling disclosure is quite common. So we might say to the other side, for instance, agree that we will provide on an ongoing basis rolling disclosure, that is, provide them with copies of documents every 2, 3, 4, 6 months. That might be medical records, case management records, and the rehabilitation records. And they want to see them for the same reason that we do, because they're so important in terms of the evidence in the case. Now, after the issue of proceedings, once the court has its first initial hearing to decide how they're going to get the case to trial, they will generally impose a requirement upon both sides to provide a list of everything that they hold that's in terms of documentation that's relevant to the case, and they will then impose a duty upon both sides to provide the other side with copies of the relevant documents they acquire as the case goes along.
Okay, so after post proceedings, then there's their obligation is there, and it's absolutely everything, isn't it? I mean, it's everything that is relevant to the case. There's you know, if a document is produced and it relates to the client post injury and it relates to litigation, it has to be included. It's just everything, isn't it?
Yeah, absolutely. We need to obtain absolutely everything, and it's quite remarkable how much has to be provided to the other side. We need to obtain HMRC records, DWP records, GP notes, the claimant may have been treated at a number of different hospitals during the course of their life. We need to obtain all of those records. We need to obtain the case manager's records. There might be lots of different private organizations involved in the rehabilitation. We need to obtain all of those records, and we need to obtain all of the records from any support workers who are involved with the claimant as well. Yeah. So it's a large amount of documentation that we need to be providing.
Yeah, and what we're after, Ben, are some juicy top tips actually today, because that's always useful in terms of practice points for people watching. And so do you have any top tips for case managers, therapy providers, anyone in the team who will be involved in generating documents and providing them to the solicitors?
Yeah, absolutely. I mean, the first and most important one is don't make us chase for them. I've already outlined, we've got a load of different documents to get in, and we might have to be getting these on every 2 months. So the last thing we need is to be chasing people for the records that we need to see. So first thing is, give them to us when we ask for them. Second thing is, I'd say is, don't give them to us in dribs and drabs. Give them to us all in one go. And third tip is, it needs to be everything. As you've rightly said, Emma, we need to see absolutely everything. So that's all invoices, all communications, telephone notes, everything written down needs to be provided to us. And the fourth tip is, some documents don't need to be provided to the other side, or at least don't need to be provided in full to the other side because of privilege. Now, whether a document is privileged or not is a matter for the solicitor to determine. It's not a matter for the case manager or anybody else in the case to worry about. So do just provide everything to the solicitor and let the solicitor worry about what's privileged. And similarly, just because a document has privileged written upon it doesn't necessarily mean that it is going to be privileged. That is a decision for the solicitor to make.
Yeah, so make life easy. We all like to make our lives a bit easier, so fob off as much as you can to us. Perfect. So moving on a little bit from documents, because these sessions just fly and we're already 8 minutes in. The other thing we were going to talk a little bit today about is expert evidence. Is there a normal sort of core team of experts that we usually have on these types of cases?
Yeah, in spinal cord injury cases, the medical side of the expert evidence will be usually carried by the spinal cord consultant. In brain injury claims, there tends to be a larger team of medical experts. There'll be a neurologist and or a neuro rehab consultant who are dealing with the physical side of the injured person's injuries. You will have a neuropsychologist who's dealing with the deficits in their cognitive functioning and quantifying what those are. So what are their problems with concentration, with reading, with understanding, memory? All of these things will be dealt with by the neuropsychologist. There'll also be very often a neuropsychiatrist involved who's dealing with the crossover between mental health issues that may be pre-existing and teasing out what's attributable to those and what's attributable to the brain injury itself. And those are really the core medical experts. Now, you may have a neurosurgeon, a neuroradiologist may be involved. Depending upon a particular person's injuries, there may be other medical fields, orthopedic surgeon or a urologist if they've got urinary problems. And then you've got the secondary experts who feed off the medical experts. So generally that will be the occupational therapist, a care expert, an accommodation expert, and a physiotherapist, all common experts that we'll be using time and time again in these cases.
Yeah, and then we do have quite a lot, because every case is so different. A lot of the time we have all sorts of kind of left-wing experts as well, don't we? So sometimes you've got to be thinking, depending on what the issues are in every case, sometimes we go pretty wide with experts as well. And I suppose something it's useful for people to know is how we choose our experts. And does it matter? You know, sometimes we hear from clients, or we had a meeting with X expert and it wasn't great. And is it important that the experts get on with our clients?
Yeah, I mean, the first thing that we need from an expert is they've got to have a great track record of being able to provide evidence in cases, and particularly in court. It's not enough to be a wonderful orthopedic surgeon if you can't communicate your ideas to a judge who is a layperson. He's not a medic by background. Indeed, he may never have dealt with an injury claim before. And unless you can communicate your reasoning in a convincing manner to a court, you're not going to be a great expert. It's really important that, experts do have to be able to get along with people, but they're not going to have the same relationship with people that, say, case managers do. A case manager is going to be seeing their clients maybe daily for the life of the case, maybe for the rest of the person's life. Yes. The expert may only see the injured person once or twice during the course of the case for an hour or two. So the relationship is far less important. Yeah. Geography is going to be an issue. Whereabouts is the injured person? Whereabouts is the expert based? Is the client able to travel at all? Is the expert able to travel to see them? Now, generally, in the type of cases that we're dealing with, our clients very often aren't able to travel. So the experts do need to be able to have the flexibility to visit people at home. And that's really important, not just from the point of view of being able to see the person, but seeing how they live, seeing how they live their lives and how they cope in their home environment may be very important for that expert.
Yeah, and just touching on what you mentioned, Ben, which I think is a really interesting point about how experts don't have that relationship with clients. I think that's a really interesting point. Because as well, I've found sometimes if a client goes to an appointment, they have all of these things in their head that they want to tell that expert, but the expert is thinking, I've got 2 hours and a very focused list of things that I've got to get through. And sometimes it maybe comes off to the client that they're not interested in X, Y, and Z that the client feels is really important. And I think from a practice point of view, it's something that case managers and solicitors can communicate to clients in advance. This is a focused session. And it's tricky. And for lots of clients, they attend these appointments with somebody, with a case manager, with someone who's supporting them. Do you have any tips for the people who are attending with clients in terms of what they need to do at these expert appointments?
Yeah, I mean, most of our cases will have a case manager involved, and I think it's really helpful to have case managers present at expert appointments, because the case manager will have an understanding, an overview of everything that's happening with the claimant, but then they're not there to impose their views on the expert appointment, but they are there to help supplement what the claimant is saying, because the claimant may have communication difficulties, they may not, they may have cognitive issues, they may not remember everything that's happening to them, or all of the interventions that they're having. So having the case manager there can be extremely useful in helping to focus what's being communicated to the expert, making sure that he's got a good overall picture of what's going on in that claimant's life.
Yeah. And we've reached the last question with 1 minute to go. So
I'll be quick.
Yeah, it flies, doesn't it? It's unbelievable. One of the most frustrating things I think sometimes is that we get expert reports in, and then there's lots of work that follows from that, and members of the wider team are keen to see what the experts are saying, and you know, when can you explain when we are able to sort of openly circulate and use expert evidence, and how much we're able to share before there's a formal exchange?
Well, in brief, we don't want to send out expert evidence willy-nilly, because once we start sending expert evidence to people connected with the case, we may lose control or privilege over it. So we tend to want to hold on to expert evidence until we're ready to send it to the other side. But that doesn't mean that we can't communicate important issues to the rehab team as they arise and are identified by our experts. But once we have our expert evidence and it's been served, we want to send it to certainly the case manager, and we'll want to be sending the defendant's expert evidence to the case manager as well, because the case manager will need to take all of that into account in the work that they're doing with the claimant, need to be able to justify potentially in court why they've taken particular steps, having had the benefit of seeing that expert evidence, which doesn't mean they need to follow it to the letter, but it does mean they need to be able to justify when they diverge from it.
Yeah, sure. And I suppose if you know that the solicitors have an expert report, they're not able to share it, it's worth picking up the phone and saying, I'm concerned about X issue, and we'll be able to guide them in terms of what we can tell them, if anything, from the expert evidence. So it's always worth picking up the phone and just asking.
Always worth picking up the phone, Em.
For sure. Well, thank you ever so much. Ben, we've only gone over by a minute, which is an absolute miracle. But you crammed so much in there. Thank you very much. I thought that was really helpful, and I hope that was really helpful for everyone watching. If there are any follow-up questions from this session, by all means, please get in touch with me or with Ben, and we'll be happy. We'll come back to you as quickly as we possibly can. Next week, I'm afraid you're stuck with me, because I am doing a session on the kind of latter stages of the litigation process. So we're talking about witness evidence from factual witnesses. We're talking a little bit about settlement and trial and all the stuff that kind of comes at the end, and hopefully that'll be another interesting session for you, but I'm afraid you'll be stuck with me. But I do have my colleague Nikki Maple Pearson, who'll be here doing what I normally do, hosting, which will be a role reversal. But do tune in next Wednesday, 1 o'clock. And shortly after our session next Wednesday, we've actually got an amputee webinar coming up, all the details on our website, so please feel free to check that out. And thank you ever so much again for tuning in. See you soon.
Bye.